All right, here we are. Welcome. How are you guys doing this morning? Good, good, good. It's hard to compare to those first presenters and hearing all the wisdom that was dropped on us this morning, but we come to you from a few different perspectives. Malaika, I'll let you introduce yourself first.
Hi everyone, my name is Malaika Eban. I'm the Executive Director at the Legal Rights Center in Minneapolis.
And we are being recorded, not live streamed or video recorded, but we are being audio recorded. So we've been asked to speak in the microphones, and then when you ask questions, bear with us. We're going to repeat the question before we answer so that it makes the recording. So sorry, go ahead.
Yeah, no, thanks. So Malaika, I'm here from the Legal Rights Center. We're a nonprofit law firm here in Minneapolis. We've been representing youth and adults in Hennepin County Criminal Court for over 55 years. We also do policy advocacy, organize and advocate with young people and their families at the Capitol and in local policy contexts in issues related to youth justice. And then we do restorative justice work in schools too. Really glad to be here with y'all.
And my name is Corey Thompson. I'm the training director for the Minnesota Public Defender System. For those of you who don't know about the Public Defender System here in Minnesota, we are a statewide organization. We have different offices in each judicial district. So we have 10 offices that do trial work sprinkled throughout the state, and then we have an appellate office. And I'm the training director for the statewide system. Prior to this role, I was a trial attorney in the Ramsey County Public Defender's Office, and we had a dedicated juvenile unit in that office. I worked in the juvenile unit for like 2 years and change. Most of my career was adult work. However, while I was practicing the juvenile unit, I definitely ran into the issues that we're going to be presenting on today. And I also sit on the Department of Corrections Justice Involved Women and Girls Task Force. It's an advisory task force to the Commissioner of Corrections. I'm not here in either official capacity today. I'm just here as Corey Thompson telling you my opinions about everything that I have taken in my various roles over the years in Minnesota working in criminal defense.
And we're curious about y'all and who else is in the room as well. So we have a little interactive poll for folks to complete real quick. You can join at slido.com, and then there's a code. You can also scan the QR code. Just have some curiosity about who's here, who's interested in this conversation, and we'll do our best to make sure that over the course of the hour we have together, we can try to hit on the things that might be important and relevant for folks. So just take a minute there. All right, we'll give it just a few more seconds. Seeing a lot of folks in the room who are community members and advocates who undoubtedly care about young people, our justice system, young women, but happy also to see some researchers, policy folks. Yeah.
And I think we only have like a handful of lawyers, which is awesome, because we did kind of gear our slides to explain some of the process. So this is good.
Yeah, absolutely. All right, let's get into it. Okay, so the main focus of our time together is to talk about young women in the justice system and the specific challenge of providing equitable and supportive interventions or invitations, like Dr. G was saying. But in line with the theme of the conference, we're going to make sure that we're not just staying in the problem, but shifting to possibility. But this is a really complex issue, and so we want to make sure that we have good grounding on it. The floor of what we're discussing today is that our justice system, especially our youth justice system, was developed in response to a community, desire and need for safety. And our youth justice system specifically was built off of the adult criminal system. We're going to go through a little bit more of the specifics of how the youth justice system works, but as you'll see, and you might already be aware, that the system acts very similarly, has similar processes and functions. And that system, the adult system, was largely designed for adult males, and so our youth justice system is largely designed for young men. So the conversation we're going to have today is about girls in the justice system, but when folks in this state and across the country are talking about the issues of gender inclusivity within the system, it's also a space where we talk about very expansive youth as well, and so we want to name that from the jump. Young women and developing young people, youth are different from one another, and girls are different from boys in many ways in terms of the ways they get into the system and their needs as they go through them. Some things that we see nationally are that young women who enter into our justice system have higher rates of mental health issues, and especially internalizing behaviors as opposed to externalizing behaviors that young men often have. So young women are often coming into the system with more self-harm or interpersonal harmful behaviors as opposed to the more external, more externally facing behaviors that young men might come in with. Overwhelmingly, young women coming into our justice system often have more extensive histories of victimization, sexual exploitation, and we are having this conversation about young women in our justice system in the context of a society that looks at girls differently than we look at boys. And so very often, young women coming into this system are characterized, and this is documented in court findings and police reports, but as being more aggressive, more defiant, more sexualized than young men presenting those same behaviors. And as a result of this grounding, this context that we're working in, a system that's not designed for them, society's expectations for young women, the ways that their behaviors and ways of moving through the world are different from boys, we have created a system that just does not work for young women. It hasn't ever been invested, young women haven't ever really been invested in fully their needs in our justice system, and they're subject to more punitive responses as a result. The issue that we're talking about today is not new. In the course of Minnesota history, there have been attempts to rectify this issue, but I think what we'll talk about over the course of this hour is that the attempts that have been made in the past haven't worked because they haven't come from a lens of possibility and haven't come from a core grounding and a desire to support young women as they are developing through adolescence, as opposed to punishing them for whatever sort of presenting behaviors they have. A few key snapshots of time that we want to make sure that folks have a little bit of history and grounding in. So in 1981, our state legislature passed a statute that said that there needs to be parity between men and women in our criminal justice system, that the legal system must provide at least equal opportunities for men and women going through the system. And 2 years after that statute was enacted, 10 years after that statute was enacted, it was expanded to make sure that there was conversation about girls. In 1992, the Federal Juvenile Justice Delinquency Prevention Act, which is the federal act out of the Office of Juvenile Justice and Delinquency Prevention, directed the states to make sure that there was intentional investment and resources allocated for young women. And then locally in 1994, there was a directive from the legislature for the Commissioner of Corrections to work in an interdisciplinary team with parallel stakeholders in human services, health, and in the private sector to try to address the continuum of needs that young women have. And yet the problem still exists today. A little bit more of a national context, so as we can imagine, girls make up 50% of the youth population in our country, but tend to be underrepresented in the justice system. Only about 30% of young people in the youth justice system identify as girls. However, they're overrepresented on that 30% in status offenses, which are offenses that just happen because a young person is underage, so drinking, truancy, those sorts of things, as well as technical violations. And across the country, we see that there are lots of different ways that identity overlap, different parts of identity overlap with gender to create this complex set of needs for young women coming into our system. So specifically as it relates to race, Black girls are 20% more likely to be detained and then formally petitioned to court compared to their white peers. We see similar, actually more exacerbated racial disparities for our Native youth, who are 40% more likely to be referred to juvenile court, 50% more likely to be detained, and 20% more likely to be adjudicated or convicted than their white peers. And then we can also overlap sexual identity on top of this as well. And we know that LGBTQ plus girls are twice as likely to be arrested than their heterosexual peers. And so that's national data, but what's happening here in Minnesota is still pretty similar.
Okay, so we want to talk a little bit about Minnesota specifically, right? And here is part of the problem. A lot of the statistics and the data that I'm going to be giving you is very dated because we haven't had sufficient studies devoted to addressing and looking at the girls' experience in the justice system and throughout placements and treatment opportunities. So the most recent comprehensive study that was done related to girls, specifically in Minnesota, was 2007. And it wasn't the government, right? It was this group Amicus, and I was trying to Google them and reach out to them, and I don't know if they exist anymore. So does anybody know if they exist anymore? You guys? Okay, well, no, they don't exist anymore, or you don't know? Don't know? Yeah, they do? Okay. I was trying to call phone numbers that were in the study. I couldn't get a hold of anyone. So either way, I feel like we need to connect with these folks again, or for you researchers in the room, right? We need to know more about what's going on because people respond to research and we don't have it. And I can talk a little bit about why that's so difficult. But at least in 2007, 35% of the girls, specifically in Minnesota, were girls, and girls were about 44% of the out-of-home placement population in Minnesota. And so the other statistics that I found specific to Minnesota come from the Office of Juvenile Justice and Delinquency Prevention. So that is a federal office that did an audit of Minnesota, and then they came up with a plan specifically for Minnesota to follow to bring themselves more in line with equity. And so these numbers came from 2017. And these numbers said that basically the boys were overrepresented in terms of juvenile arrests. They were 51% of the youth arrested. Girls were underrepresented. They were 49% of the youth population, but 32% of the juveniles arrested. So this is specifically, though, for juvenile delinquency cases, right? So criminal behavior. I think it's important for us to note that this is not the only way that girls end up getting held in the juvenile detention centers. And so girls, part of the reason why we don't have as much time devoted to them, as much study devoted to them or resources is because there's this perception that it's not that big of a problem, right? Like the boys are the bigger problem. We need more resources dedicated to them. So, this is a smaller number. We're not going to dedicate resources because we're going to pay attention to where the biggest need is. I think that is probably the way that people are thinking about it, or at least the people that make big decisions about where money goes anyways. So I'm not one of those people, so I can only surmise. But what I think is important to note is if you look at the statistics through a different lens, which is through the truancy runaway lens or the status offense lens, you see that actually girls are the majority of those people that get brought into the system. So boys, 51% of the youth population, 48% of runaway arrests. Girls, 49% of the youth population, 52% of those arrested. So when you look at it from the delinquency lens, it looks like they are underrepresented. When you look at them in the runaway lens or the status offense lens, girls are overrepresented. And this is important because of this notion of bootstrapping. Anyone heard of this before, bootstrapping? You know what I'm talking about? So basically, it's this. This is how I've seen it play out. A girl that I might represent in a runaway case has been assaultive in a handful in some of her placements. and then they no longer have placement options in the human services realm, right? But she hasn't committed an offense, right? She's not a delinquent. So what they will do is they will bring her in on a runaway case, and they realize that they can't hold them in the JDC. So girls or boys, they cannot be held in the JDC for over a certain amount of time on a runaway case or a truancy case. They can be held much longer if they have a delinquency case. So what you see then is the state and probation officers and social workers kind of thinking like, well, is there a way that we can just like maybe charge one of those assaults so that we can keep her in the JDC because we're afraid of what will happen if we release her into the community. She won't be safe. So for her safety, we will try to figure out a way to bring her into the juvenile justice system through delinquency because we don't want to release her home. So that is why you see these numbers. And that is, I think, part of the frustration that I've seen and had over the years, and many of my colleagues have, is that we're basically coming up with this notion that we are going to charge girls with crimes for their own good because we don't want them to be released because they might get harmed in the community or whatever else might happen. So let's start there. Any questions about that so far? All right.
Well, Corey, I'll just jump in on that as well,
Yeah.
because I think that there is a significant amount of paternalism in our youth justice system in and of itself, right? That is how the system was designed, this notion that we need like a caring adult, a sensible adult, the judge, to step in when families can't step in or young people are too incorrigible or whatever. So that applies for every young person in the system. But as you're saying this, like, for her best protection is a very unique layer that is specific for young women. And again, I'm just like coming back to what Dr. G was saying, you know, we can talk about policy solutions and change state statute, but there's a part of that changing the lens to the mirror and putting our, like doing that reflective work that every individual in our system, whether you are like the judge at the head of the table or just a community member thinking about or supporting a young woman, to think about that like reflective piece. What are my assumptions about this young woman and what would be in her best interest?
Yeah. And so here's some other data from 2015, and this came from this one was actually a Minnesota Management and Budget study, right? So they're just studying the cost of all this, right? So, and this is not specific to girls or boys. They didn't break out any of the statistics by gender. So they did this whole study about how much this is all costing us. And in that study, they found that American Indian youth compared to white youth 3 times more likely to be arrested in Minnesota, 5 times more likely to be put in a secure detention. I mean, you can see the disparity. Black youth, 4 times more likely to be arrested, 2 times more likely to be referred to adult court, 50% less likely to be sentenced directly to probation. LGBTQ youth are also at greater risk of delinquency and have their own unique issues in terms of trying to place them and find appropriate placements for them that they won't fail out of or get maltreated in. So that is a huge concern for those kids. And here's what I will tell you. This is not unique to boys in Minnesota, right? The intersectionality is definitely at play with girls, just as it is at play with boys that come through the system. And I kind of wish they would start looking at gender. So you notice the theme here? I kind of wish they would start looking at gender. I kind of wish they would start devoting some of these resources to being a little specific. And here's what I'll say about our organization. Here's what I will say about our organization. So I work for the Public Defender's Office, and we have a great tech department, and I went to them and I said, hey, I'm doing this presentation. Can you tell me like how many girls we've represented over the past, 10 years or, and can you tell me like what placements they went to? Like where did they end up going? Like, how many of them were certified? How many of them were this? And I'll say that our organization does a great job of of many things, but we didn't keep track of where the girls were placed. We probably have paperwork in our individual offices. We do have paperwork in our individual offices and case files, but we don't put them together on a statewide basis. And that's something that, you know, this presentation has taught me that I need to try to push for in my own organization. But what I can tell you is that when I pulled all of our open cases in 2023, girls are between 19 and 30% of our juvenile and CHIPS, child in need of protection cases. So those are our numbers, and you might think that that's like a relatively small amount, but in 2023, that's 3,280 cases, okay? Now that's cases, not kids, right? So sometimes kids have multiple cases, but that's a huge number, right? So, I mean, this is representative of, you know, the girls in Minnesota that our office is representing, and I can tell you that most, I would say we represent probably 99.9% of the girls that come through the justice system, or the criminal system. I don't like calling it a justice system because I don't think it's just, and I think that's what we're getting at here. So, any questions about statistics before we get into some of the ways that this plays out? Yes? Yeah.
One of the slides said that the budget office paid the first juvenile justice report. Is that suggesting that they're doing that juvenile justice report annually?
I don't know. I really don't know. That's the only report that I found. That's what I'll say. So I don't know how often they do that. I don't know if it was the first one, unless it was on the slide, because I copied it from their study, so then it must have been the first. But I don't know. And I hope that if they do it again, they include girls specifically. Yeah.
So you say that women are charged with status offenses and protection to not go back and fight up in the community, and the reason for that is because the community's like not good for them, is what you're trying to say?
That's the perception.
Yeah.
So there is a perception, and so oftentimes it is a situation where it could be that they could have an open child protection case, so they're not able to go back to their family of origin, right, for whatever reason. It could be, a lot of times this comes up with girls that have been trafficked, and they're concerned that if they release them, they will go back to their traffickers. So there are some legitimate reasons to be concerned. And then there are some situations where they just don't really know what to do, you know? And it could be that the girl wants to go back to the parents' house and can go back to the family of origin house, but they call her a run risk because she has a history of running and running away, and they don't believe that she'll stay. So there are a lot of different sort of factors that make people inclined to hold them in the juvenile detention center, which is for delinquent youth, instead of releasing them back into the community. There aren't enough shelters either. And there's also, when you get into the juvenile system, there's a lot of conversations between locked placements, unlocked placements, and you can only place kids in certain placements depending on the circumstances. So it's complicated. 150 billion%. Yes. There you go. You've given away the entire presentation. Yes. Yeah. 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 So the question is, how often are the girls kept in the criminal justice system? If it's a sentence? If it's for their safety. So that is something that really depends. There's not a set answer. We have had cases where it can be weeks, it can be months, it can be a day, it can be an hour. It all depends on what placements are available to put people in. There is a kid up north right now who happens to be a boy who's been held 8 months. He was found incompetent by the Rule 20 process. He's not competent to participate in his own defense. He's a kid. They don't have anywhere to put him, and he's been sitting in the juvenile detention center for 8 months. That's the most egregious thing that we have going on right now. It doesn't involve a girl. It involves a boy with significant mental health issues. And it's like, nobody wants to release him because they don't, I don't remember if he's considered to be a ward of the state, but, or his parents they don't have the capacity to keep up with his significant mental health needs. So these are not, that is an extreme story, but this is not, I just had a meeting with about 50 of our juvenile practitioners yesterday, and the whole point of the meeting is like, what can we do about all these kids getting illegally held? Why won't the courts listen to us? I think if you guys have seen the media from Hennepin County, there have been contempt charges filed against them because they're not releasing kids, they're illegally being held. And so it's a huge problem. And we're all kind of spinning our wheels trying to figure it out. Yeah, one more, yeah. Yeah, okay, so the question, as I understand it, is once girls are released, is there a pattern of them then getting brought back into the criminal justice system as girls and or women, or both? Yes. Yeah, the answer would be yes. And like, I would say that untreated girls are girls who don't have the opportunity for programming and to get, healthy and be in healthy communities and engage in their dreams and healthy pursuits, end up as women in the adult system. So, and we'll talk about that a little more, yes. Okay, so the question is about the parity statute. Yes. Yeah. Yes. You want me to tell you about that? I will tell you about that. So the comment concern is that we have this parity statute, and it would appear on its face that it says that we have to treat boys and girls the same or equally. And we all know that equality and equity are not the same thing, right? We need equitable programming for girls, which means we need equitable programming that is suited to girls and for their specific needs. We're not just going to shrink it and pink it for girls, right? That's what they're trying to do. And there are programming options that are coming around, that are available, and that are trying to be culturally specific, gender responsive, all of those things. And we'll talk a little bit about that. But again, you've given away the whole presentation because that's 100% what... Oops, I'm getting a little too wild up here, sorry. That is 100% what we need and where we perceive a lack, and you have it right on. So this is Paula Schaefer, who's a wonderful ally of all of us and has contributed greatly to this work as well. And she is reminding us that the intent was for the parity statute to be more equitable and instead of equal. But it just hasn't really played out that way. Yeah. Okay.
And Corey, too, I'll just add to the piece from that question in the background, is getting into the system a way that keeps people in the system? And the data plays that out for youth across the spectrum as well. We know that in Minnesota, about 80% of young people are in the system for misdemeanor offenses, right? Coming in for small level offenses. That doesn't mean that we should minimize the importance of young people being law-abiding and participating meaningfully and positively in our communities. But very often we see young people coming in for offenses that are typical adolescent behaviors or slightly atypical adolescent behaviors. But because of the way that we've designed our response and interventions, we end up with over serious responses that only then continue to perpetuate young people's involvement in that system. Corey gave the example earlier about like someone who might be in an out-of-home placement, and let's say you get an assault charge within that placement because for a number of reasons, right? You could actually get into a fight, or you could be like having a hard time controlling your body and accidentally hit somebody, and then you're charged with an assault. And then that allows the system to do that bootstrapping work of keeping a young woman in the system for her protection. But it's a very like slippery and fast line between a young person who's showing typical adolescent behaviors into, wow, I'm 17 and have been out of the home for 6 years.
Yeah, and there have been studies done, I think, generally on like the connection between kids involved in the CHIP system that then end up with juvenile cases. I haven't had a chance to pull that or look at it, but it's been a while, and it would be great to look at that as well through the context of how many of these situations that are leading the girls into the juvenile justice system or juvenile criminal system came from situations that happened while they were put in inappropriate programming. So that's kind of where we're going next. Okay, I'm really glad that you're not all lawyers, because I was worried that this stuff would really bore you. It might bore you because you're not lawyers, but also I think it really plays into what we're talking about. So these are the factors that the court has to consider when it places a kid out of home, okay? They're found in the juvenile delinquency rules. They have to weigh out, and there's like some case law on this, and there's a few more than this, but a lot of the legal stuff that I'm presenting to you, I purposefully sort of like made it, tried to just kind of make it clear and easy to communicate to you. So just know that what I'm presenting on you legally is more nuanced than what I'm giving you, but this is a starting point. So they look at the seriousness of the offense, the culpability of the child, prior record of delinquency, and programming history, and proportionality. So they're supposed to give them the least restrictive placement, right? Which is always in the home and maybe a class, okay? But then the more these factors weigh up, so the more, if a girl or a kid has been put in a lot of programming history and they've failed out of the programming history, or they've been terminated from the programming, then that factor starts weighing in favor of putting them in increased levels of programming, longer, more locked, things like that. And same with the prior record of delinquency. So that bootstrapping problem, right? If you're starting to bootstrap status offenses for their safety, then you're racking up this factor. So the more those things increase, the more likely the girl is to get placed out in a more serious detention center. And then we have a certification problem, right? So one of the factors that a court looks at when they are looking to certify a kid as an adult is their prior history of delinquency, their prior programming, all of those things. So when we talk about certification, that's when a state makes a certification motion. They say, we want to certify this kid as an adult. It's the same for boys and girls. If it's granted, the kid is certified as an adult, they go into the adult system, they're going to get an adult consequence. If they're not certified, there are two sort of choices that the court has. They can keep them in the juvenile system, or they can do this thing called EJJ, Extended Juvenile Jurisdiction. What that basically means is you are in the juvenile system on probation, but you have an adult sentence hanging over your head. So if you violate probation, you go to the DOC, adult prison, basically, somewhere. So for girls, it's Shakopee. For women, it's Shakopee. For men, it's a variety of other places, and we'll talk more about that. So if the court is looking at an EJJ revocation or a probation revocation, they go through these things called the Austin factors, right? It's in case law. They have to make findings about them. They go through all these factors. The one that I have in red here, child is in need of correctional treatment, which can most effectively be provided if they are confined. That's what we're talking about. So when the court goes through and decides, like, all right, we have a probation violation, what are the treatment options in the community, right? Because they're supposed to go least restrictive first. So first they're supposed to look at treatment options in the community. Well, if you have no suitable treatment options in the community, then they're going to end up going and getting placed away from the home. Sometimes that's in a geographic location close to where the girls live and where their family of origin is, and sometimes it's not. I've had girls that have been placed in Arizona, Utah, a variety of places. Sometimes they go up north. We have a whole list of places that girls are going. We're considering asking for some girls to get sent to Milwaukee because we don't have programming here that fits. So through this lens now, I'm hoping that you can see basically the start of a pattern, right? And now this is where like equal protection enters a little bit, okay? So equal protection is a constitutional provision, and it basically, like at the basic level, it's like, hey, we should just treat everyone the same, right? Like everyone gets equal protection of the law. Similarly situated people should get treated equally, right? It's not equitable protection. That would be like a nice like point 2024 update, but we're not there. We're not going to change the Constitution anytime soon. But at any rate, like we already have this protection, okay? Or we hope we do. And so the history of equal protection, it was passed to enforce the Civil Rights Act, when we were moving, when the federal government had to basically force the states to follow the laws for equity and equality. It was the basis for Brown versus the Board of Education and Obergefell versus Hodges. So, it's been used to do a lot of really good things. My other like side note tangent that I'm learning about in terms of equal protection is that it's also being used by some wealthy white people who want to attack ICWA to make arguments that it violates equal protection for Native American kids to be placed with tribes instead of white people. So, and they're using that basically as a way to try to right now Native American people are more classified as political, and tribes are political entities rather than racial entities, which is important for keeping tribal land rights and things like that. They're trying to attack ICWA with kids in the CHIP system, with Native American kids, to try to reclassify tribes as racial groups so that then they can take their land. And this has happened, there's a Minnesota case about this too. So the frustrating thing about equal protection is that it's kind of being weaponized as well as, not being enforced in our cases. So we'll keep going. All right. So we know that there's a lack of gender-based culturally responsive trauma-informed programs, which means that this factor is going to always weigh against girls, basically. And I want you to remember that, again, in the context of runaway arrests, while we're also talking about the juvenile justice system. And the issue is when you put a girl in a place that she doesn't belong in, and that isn't culturally responsive, and that isn't gender responsive, and that isn't meeting her needs, which courts will sometimes do because they're like, well, we don't really have any other options, so let's try this, and then you put a girl in that kind of a situation, and she's gonna run. That's just what people do. That's what girls do. You're not gonna succeed in an environment where you can't grow, thrive, and heal. And so when they run, then they're terminated from the program. And then when they fail, it goes back to that factor. The child is in need of correctional treatment, which can most be provided if they're confined, right? So you see really that this is just the cycle that happens. It starts with trauma. Girls are in the system because of trauma. Every time they run, it's traumatic. Every time they go to court, it's traumatic. The justice system is not, I keep calling it the justice system, but you know what I mean. Like it is a traumatic experience for everyone. So we have this cycle where the girls are getting inappropriate programming or no programming, then they may run or catch a new case, and then they have a failed placement or treatment, and then it weighs in favor of this factor that keeps them incarcerated. And all of this is in the backdrop of significant trauma. And so boys, there is this interim placement called Red Wing. Have you guys heard of Red Wing? Raise your hand if you know Red Wing. All right. Boys. And I'm not saying that Red Wing is perfect, right? But what I will say about Red Wing is that it is the place for boys who are on EJJ probation. So remember back to that concept of we're certifying you, we're not going to give you the adult sentence. We're going to keep you on probation with an adult sentence hanging over your head, but you're going to be in juvenile probation, right? A lot of boys that are in that situation will end up going to Red Wing. It is a locked DOC placement, but it is not there. It is not an adult prison. It has programming. It's about, I want to say it's about like around a year maybe. Some of the programming is about a year, I would say, on average. And there are boys from 10 to 21. So it has some technically adult boys that can go there. And so this is Red Wing. There is no Red Wing for girls, okay? We don't have this. There's no like locked DOC facility. There's no place like that. And here's the hard thing, right? Like, I don't necessarily want them to build one of these, because what did the guy say out there earlier? You know, what did he say? He was quoting a movie, and he said, if we build it, they will come, right? Like, we don't necessarily want to build a new facility that they're going to fill up, which is why I think it's important for us to think about the fact that, yes, this is a factor and a problem when girls are getting their EJJ probation revoked, right? But it's a factor before we even get there. It's a factor when we're looking at places to help them heal to begin with, and we don't have any good options. So I believe that if we created those places for girls to really heal that were specific for them, we don't need another Red Wing, right? I don't think we'll get to this place. But Red Wing is important to our conversation about equal protection. So for that reason, we're going to go there. All right, Shakopee Women's Prison. So if a girl is certified, if a boy is certified, they go to this place called the Youthful Offender Program in Lino Lakes. It is like a separate unit for underage boys within the adult prison. I've visited it, I've toured it, it is not great, but they are together. They have programming, they go to school, they are together. Girls go to Shakopee. And Malaika, you want to talk about that experience?
Can you imagine?
Not that Malaika was incarcerated,
yes,
but Malaika has spent some time.
Yeah, I mean, can you
Looking into
imagine being a girl at a women's prison, right? Can you imagine being a child in a prison, period, right? Horrible. Corey's not alone. Like, we are not up here advocating at all to create a specific young women's prison in the state. Couldn't be further from that. But for young girls who are sent to Shakopee, the experience is nothing short of a traumatic experience. Because of PREA, or the Prison Rape Elimination Act, there has to be sight and sound separation between youth and adults in correctional facilities. This is a federal law it's a requirement that is intended to keep young people safe. But what that means for girls who are placed at Shakopee is that they are functionally isolated their entire time there until they turn 18. So young women are sent to Shakopee and in mods or pods or housing areas completely by themselves. They always have to be one-on-one with a staff. They're not able to participate in general programming like a book club or a reading group or anything like that unless there is staff present. And as you can imagine, the other women in the facility aren't too keen to have a ton of correctional officers in the rooms with them constantly. So what that really means is that girls there are living life completely by themselves in cells until they turn 18, and then they're placed into the general population. It's just like a horrible, horrible thing that we do to young women.
They're in segregation. I mean, yeah. So if a girl gets sent to Shakopee, because there's not an interim Red Wing for the girls, and there's not a youthful offender program for the girls, they're basically in seg until they are in effective segregation until they turn 18. Yes.
I'm so sorry if I missed this.
Yeah.
Who is the decision maker, the ultimate decision maker, in a girl that is on a trial or in the pre-trial system gets sent to one of these facilities? Is it judge?
So the question was, who's the decision maker as to where they go? The judge. So what happens is We're gonna go there right now. Okay, so I'm gonna do a deep dive into a couple of recent cases for you so you can see how this plays out. But the short answer is it's the judge. All right, so equal protection case law. There's two recent cases that I want to talk to you about, 2021, 2024. So our lawyers around the state have been trying to make equal protection arguments in these cases saying, hey, girls don't have the same equivalent placements or placement opportunities as boys, and this violates equal protection, so do something about it, basically. And here is, I'm going to start with the first one. So the first case that we had that went to the Court of Appeals was an MNM. You can look these up if you want to. 17-year-old girl, when the offense occurred, she was put on EJJ probation, right? So she is a person who's in the juvenile system. She's on juvenile probation, but she has an adult consequence hanging over her head. At the trial court, the defense attorney argued that there was an equal protection issue because when she went for a probation violation hearing, had she been a boy, they would have put her in a place in Red Wing. She had the same kind of background, like we all know she would have gone to Red Wing, but there was no Red Wing, so she got sentenced to Shakopee. And the trial court even made a finding. An equal protection issue continues to exist as to correctional placement options for female juveniles. They said a boy will go to Red Wing, there's no functional equivalent. So the judge at the district court is like, yep, equal protection, problem, right? So like, awesome. I mean, not really, but good, right? Step in the right direction, good court order. But the Court of Appeals, not so much. They said, we acknowledge the district court's concern and frustration. I'm like, oh, you acknowledge our concern and frustration. That's so nice. Anyways, we acknowledge the district court's concern and frustration about the varying levels of programming, but counsel didn't make a record including all these things. So this case said, well, the lawyer down at the district court should have made a record about the admission criteria for Red Wing, which everyone knows, but you know, we do need to make a record in court. So I'm not gonna go off on a tangent about this. I'm gonna try. The number of males rejected for admission, varying levels of programming at Red Wing and Shakopee, one-on-one programming, number of males that had EJJ revoked, whether they would have accepted her if she was a male, right? So they said, you didn't develop the record. The state had appealed this one, and they said, you didn't develop the record. So now we move on to 2024, and we're like, oh, now we've got it. You gave us very clear instructions for the things that we are supposed to like prove up. The lawyer went into court and like introduced all of the things from MNM, using it as sort of a guidepost, checked all those requirements that the Court of Appeals set up for us. And then comes another case, SDG. Here's the thing. At SDG, the parties agreed that there was an equal protection issue. So the parties, like the state, the prosecutor, and the defense attorney were like, yep, we agree. This violates equal protection. And the state and the defense both agreed that the treatment options do not exist for female juveniles, both while in EJJ probation and in Shakopee, and that they were not appropriate for this girl for numerous reasons, including, you know, behavior, all these things. So, right, like both the state and the defense are in agreement. We're like, yes, there's an equal protection clause. We've made the record. We should have won, right? We did not win. The court just punted it. I mean, and here's what I'm telling you guys. The courts are not going to help us here. They're just not. They're not. So the court said, basically, at the end of the day, they said that they had no control over the Commissioner of Corrections and that this isn't really an equal protection claim. The commissioner, because they're not a party. So it's basically saying we're not going to involve ourselves in this. Yeah, I know it's confusing. Go ahead, ask away.
No, I just have a question because
Yeah.
I saw it was like the court rules, like, and I'm not advocating for this, but
Yeah.
what would happen if we put some of these court rules into statute so the only person that's interpreting them isn't the judge? It could be the Commissioner of Corrections, or it could be.
So,
I just.
yeah, what would happen? The question was, what would happen if we had court rules that, like, basically that
We're just put into statute. I guess.
put it into statute?
I don't know, that guy, like if the state statute
And this is what they have to choose. Yes, so those factors come from case law, which is always kind of interpreted by the courts. Those factors are also in the juvenile rules of procedure. And we have, I mean, we saw one of the first slides that we have statutes that say that the Department of Corrections are supposed to like equitably take care of this problem. So it's in statute, but what happens is the DOC is like, well, we just don't have like those placements because we don't have money. In the meantime, they're doing, Ramsey County right now has a whole new great holistic program that they're creating for boys, like no equivalent for girls, right? So, I mean, it's just, I don't know what to tell you. I'm as baffled as all of you are. Yes?
So that leads me then to like what, and maybe you'll talk about this, but then what's the next step? If it's the Commissioner of Corrections, if it's the DOC responsible, what legal?
So the question is, what's the next step? Okay, so here's what's actually happening in these cases. Both our office and the state have filed for what we call a PFR, a petition for review to the Supreme Court. The Supreme Court can decide whether they are going to take it and think about it and come down with a decision and address it, or they can say, nope. So we're waiting to hear whether the Supreme Court is going to take this up, basically. But both in the petitions for review, both the defense and the state filed motions saying, essentially, kind of on the same page, like, hey, and plus, this isn't just a DOC issue because of this factor that you use, right? It is part of, this is like case, you have basically codified the DOC and placements as one of the legal factors that the court has to consider when revoking probation and when placing kids. So this is not a DOC issue. This is now a legal issue because you have incorporated it. So that is part of the argument. And the frustrating thing about it too is like, to appeal a case, we have public defender's offices who will take these appeals. To sue the DOC for equal protection, we need private attorneys. And I'm sorry, like what 15-year-old girl that's locked up in a JDC has the money to pay a private attorney or the resources or the wherewithal to be able to seek out private attorneys? So if you guys know some private attorneys, tell them to start like filing lawsuits. I don't know. Yes?
Minnesota Supreme Court compel the Minnesota legislature to provide a resolution to the disparity. Clearly, this thing is headed in this direction that there is inequality, and so what do we expect, could happen here?
So the question is, could the Supreme Court compel the legislature to fund these things?
Department of Corrections, the Commissioner of Corrections says that I don't have
Because the commissioner says I don't have money. I'd love to.
I don't have any resources.
No money.
Their
Yeah.
resources come from the legislature. And so the legislature, clearly from the budget office, has done some review of all of this.
Yep.
And they've come up with some analysis. They maybe were doing ROI to determine whether or not there's some benefit to provide this, or it's cost efficient in comparison to what we provide for boys, all of those.
Yes. I think the answer is, it's a very tricky constitutional law question, and I would say, like, there's the separation of powers issue that prevents the courts from ordering the legislatures to fund things, right? So that's a problem. However, they could start finding that there's equal protection issues and releasing people and saying, like, hey, you got, we're not going to let the lack of funding, allow everyone to act illegally and violate the Constitution, right? I mean, that's where it starts, I think.
And I would say because of the separation of powers, since the court probably cannot direct the legislature in that way, we could, though. Like the community could, and the advocates in the room and the researchers in the room could help us in providing whatever, convincing more information that the legislature needs. But I think really it's about people power at this point to demand better for young women.
That's exactly it, yes.
I have a question.
Yeah.
I'm an attorney in a prosecutorial office, and I've been in my office for 30 years. This is not a recent problem. This is an issue it's an historic problem at least 30 years. Would you address the issue
Right.
Yes. The comment question is, this is not a new problem. She's been in the prosecutor's office for 30 years, and so where is the will to do this? That's kind of where we started too, when we showed you all the parity statutes, right? Like, there's just not people willing to devote the money to this issue, and I don't know why. I mean, I have a lot of ideas of why, but a part of it is, for whatever reason, people don't believe people don't believe what people are saying. There's newspaper articles about it, but they need data, right? For whatever reason, we all need data to like drive the boat on this, and nobody's collecting the data. And it's hard. It is hard because we need all of these programs, right?
Yeah. And none of that is super surprising, right?
Right.
Like, all of these things are like
We
what
kinda all know
every
this.
young developing human needs. And certainly as a young person who has been identified to have specific needs, we might say, yes, healthy relationships training, or family counseling, wrapping our arms around young women. Like, I think that there is often also a narrative that like we don't know what to do, and we do. We do it really well in wealthy communities and white communities to support young women when there are challenges. We just haven't, like, I think, built up the courage and the pressure behind those policymakers who have the courage to say, like, we're done. No more girls can be treated like this.
Yeah. And so we need gender-specific programming. We need cultural-specific programming. We need girls' courts. We need to really start digging into providing these resources, because the problem is everybody blames the girl for failing when we've failed the girl, right? Like, we have failed the girl. And so we need, yes? Yeah?
You give those to people that you think deserve it. The narrative has guided how we've treated girls, not just 30 years. I was well into the big movement 30 years ago. It was 20, 50 years before that. We put money into those things we value and we care about, and resources. We don't care about these girls. The narrative about girls has always been that they're manipulative, they're dangerous, they'd sooner hurt you before, rather than look at you. That's the narrative. We have to change the narrative. Because the girls currently in the system, they don't deserve that. And who are those girls? So I think that's, I'm sorry, I just had to say that.
Yeah.
You're right.
We've been fighting that narrative for, over 100 years when you
Yeah.
look at it.
If you're interested in getting involved with us on some of this work, come see us after the presentation. We've got some bills we're working on in the legislature this year that are specifically focused on the general issues of the youth justice system and related to the conditions of all young people in correctional facilities. The fact that we don't have the data on how many young women we're talking about, there's no one in the state today who could tell you how many young women are out of home. There's literally no one could tell you this
Nobody.
information. And so we need the data. Certainly that might help convince some people. We need better administration of our youth justice system broadly and more specific support for young women in general. But to Paula's point, and maybe to close this out as well, all of what really has to come is a fundamental shift in how we approach young women when they cause harm, when they have needs, that our approach has to be rooted in care, a love for our neighbors, an urgency for this moment, a willingness to say, not one more girl on our watch, an honest reflection on what we're doing and how truly harmful it is, and an appreciation for each and every young woman that comes through our system. And I think we can all be a part of that in the everyday conversations we have with our neighbors, but certainly in the advocacy that we can do as well.
So we'll take a question, but while we answer this question, if you want to get involved, there is a group of us that are trying to form community across agencies to try to maybe lobby and figure out ways to become a little more involved to try to get the resources that the girls need. So scan the QR, sign up here, and then go ahead. Yeah.
First, just wanted to thank you both so much for your incredible work. Thank you so much. I know how hard it is. And then I was going to just say, too, that I think a lot of this is really, what I've learned and always am learning is that the girls will tell us what they need.
Yes.
If we allow them, an equitable voice in designing the interventions and
Yeah.
successful. So that would be one line, and if we can get that into the legislative request that we're asking, is
Yeah.
that girls and or youth with lived experience have to be co-creators of the
Yeah.
response. That would be, I know I'm singing to the choir like that, okay?
Yeah, bring the tiny humans
Yeah.
along. Yeah.
Yeah.
She's the one that's always bringing youth for the link and everything, so I'm not saying you're not. And then the second thing I would just add is just that, and this is just a plug for all of us that do these interventions or 24/7, residential responses for youth or girls that can't be safe and reunified, is we have to be able to invest in those appropriately.
Yes.
We feel like smaller, non-institutional, non-correctional settings,
Yeah.
trauma-informed work best.
Yeah.
And they are very cost effective in terms of what we're spending on correctional placements.
Yes.
However, we need to invest more in them because there's not a lot of organizations that are able to do it. It's really difficult.
Yeah.
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 Yes. Yeah.
I know you're not here in your official capacity, but you talked about the task force on women and girls.
Mhm.
I'm curious, as we're talking about like gathering sort of like the folks that can make decisions and like putting the money there and going to the legislature, like where do they fit in and what are they doing, both around the data piece and like the advocacy and change piece?
So what the task force is doing or what the DOC is doing?
What the task force is
So what we are an advisory group to the Commissioner of Corrections. So traditionally, what we do is we look at we look at different problems as we see them. That we put in some research, and then we make suggestions to the commissioner or reports, and asking them to change policy or to do things differently in-house at the DOC. So that is, so we're supposed to advise the commissioner on how they can do things better in-house. So it doesn't, and of course, and we have had conversations with Commissioner Schnell about, these issues as well. I mean, and I think everyone is a little concerned about building something. We don't want to see more kids incarcerated, right? And the problem with working with the DOC is that it's that same model. It's like the old house model. It's that same model. So we really do need to reimagine things that are more community-based, more holistic, more healing, more culturally specific. It's like a home. These girls need homes, right? They need a place to heal. They need a place to heal and figure out their life purpose and follow their dreams and get us to help them to follow their path that they are here to be on. Mm-hmm. And their path is not to Shakti.
Yeah.
And that's what frustrates me about this is like I just see so much hardship and creating more barriers to young people being able to fulfill their place in this world and making this world a better place. Mm-hmm. And that is just heartbreaking.
Absolutely. Thank you all so much for being here. We really appreciate it. Please do let us know if you want to join. We really want y'all.